Well, very good morning, everyone, and thank you for joining us today, Thursday, 4th of February, for this Meyerson Brexit team webinar. If I could have the first slide, please. If you don't know me, my name is Terry Moore, and I'm a Senior Associate in the Corporate Commercial Department here at Meyerson. I'm joined today by two of my colleagues, Patrick, an Associate in our Employment Department, and Suzanne, a Senior Associate in our Commercial Litigation Department. Before we begin today, I'd just like to let you know that today's webinar will likely last around 50 minutes to an hour, with questions and answers at the end. Throughout the presentation, you are welcome to add any questions you might have in the Q&A function of Zoom below. We will try and answer all your questions, time permitting. We will also be recording this update, and we will circulate the video link to those of you who have attended today via our Meyerson YouTube channel. So having said that, please let me begin today's talk. And if I could have the next slide, please. So as we will probably all be aware, on 24th of December last year, after protracted and intense negotiations, the UK and the EU agreed what is now known as the Trade and Cooperation Agreement, or the TCA. The TCA took effect from the 1st of January 2020, which coincided with the end of the transition period. And yeah, it's obviously a very, very complex and far-reaching document at over 1,200 pages in length. Inevitably, both sides had a bit of bluster after the deal was reached, but inevitably, with a deal this complex, there are certain wins and concessions on both sides. Interestingly as well, despite being 1,200 pages, this is a deal which still leaves a lot unresolved. And so, we do envisage that there are going to be significant developments to this in the years and decades to come. There is a 5-year review mechanism in the TCA, which is relevant for a lot of different areas. There are likely to be addendums sort of added to the TCA over time. And so this is very much a work in progress, is how I see it. We will try and touch on some of the main themes of the TCA in this discussion today. Do feel free to follow up with us afterwards if you want to touch on any particular issues in more detail, as time does mean that we need to take quite a broad brush approach to the manner of the discussion. So if I could have the next slide, please. Probably the main, I guess, probably considered the key win for the UK government was the tariff and quota-free trade in goods. Now, this is genuinely something of a win. Some people say that it's to be expected, but I would say it is something of a genuine win. The EU has never agreed to a genuine tariff and quota-free trade deal with any other country or nation before. Normally you have this sort of ratchet mechanism, which even then the end goal is not always tariff and quota-free trade. So it's something of a win, but there is one caveat here, and that is tariff and quota-free trade is only for originating products. It's probably beyond the scope of this webinar to do a deep dive into the rules of origin, which themselves are very complex. But each different product line has different rules and different thresholds. The good news is that there are accumulation rules within the trade deal, which means that EU materials and processes can be recognised as UK materials and processes, and vice versa, which does promote greater scope for what is deemed to be originating products. But the key takeaway really is if you are a business who trades in products with the European Union, then make sure you're familiar with the rules of origin for your own products, and do familiarize yourself with the accumulation rules if applicable. You might also want to think here about how the risk is going to be apportioned. Now, if you are an exporter of products, you probably naturally will carry more risk. The importer might require you to give assurances that the products are originating, and indeed you might be expected to give a statement of origin for customs purposes. But if you're an importer, you may want to take further contractual assurances, take a warranty that the products are genuinely originating, because the importer will be making the onward claim for the duty relief. Touching on customs controls, unlike with the tariff and quota free, this was not really dealt with in the same manner. So from the 1st of January 2021, the UK and the EU are two distinct legal jurisdictions. And so what that means is all customs controls and formalities do apply, as at the beginning of this year. For UK traders who export products, that means that the Union's customs code will apply in the same manner as it applies to non-EU countries. And so UK traders should become familiar with that. Customs declarations now needed for both imports and exports. There are a few things you can do to try and ease the burden and avoid the significant delays, which we've all seen, headlines about recently. You might want to outsource this to a specialist courier service. The other point here is the TCA does give recognition to the Trusted Trader Scheme, which is a scheme by which trusted traders can circumnavigate some of the sort of customs processes. So worth exploring if you do a lot of import and export, although not an easy process or application process in itself. If I could have the next slide, please. Technical barriers and regulatory issues, again, similar to customs issues. The UK is not, is it now its own legal jurisdiction for all purposes, and there's no longer the harmonised approach to conformity standards, which we will have previously been used to. That does mean that if you're exporting products, they will have to comply with the applicable compliance checks and controls in each individual country to which you're exporting to. And likewise, the checks will take place on import of products as well to ensure they comply with our standards. Again, if you are a significant importer or exporter of goods, make sure you are comfortable with the requirements of the countries you export products to, whether that is to standards, compliance, labelling. It might be prudent to take local advice. The TCA does allow manufacturers to self-certify for probably most products. It's a large number of products, and so that will help to streamline this process. But the key takeaway here is you need to be aware as to what these new measures look like, and you need to make sure it's not impacting on the supply chain and creating significant delays in terms of ongoing projects. Next slide, please. What does this mean for contracts? Well, I would say that now is a good time to carry out an audit of existing contracts. We've all no doubt had a challenging 2020 with the pandemic, and on top of that, Brexit adds a new layer of complication. So now is as good a time as any to carry out that internal audit, do a risk assessment and see where the issues might lie should delays at the borders, etc., become a significant issue. I would also suggest to take great care about new contracts. Do review your standard terms of business on which you supply or purchase goods. Do have a look carefully before entering into long-term commitments, such as long-term supply contracts. And if you trade on the Incoterms, make sure you understand exactly what those Incoterms say on issues such as tariffs and duties, which now may become more of an issue than perhaps you've been used to in the past. Just looking at a few of these issues on the screen. SLAs and KPIs, this is service level agreements, key performance indicators, essentially anything where you are giving specific assurances as to delivery dates or project milestones. Does your contract say that time is of the essence for delivery, or do you guarantee a particular window? Extra care does need to be taken there in light of border issues and the impact on the supply chain process. Compliance, as I've touched on earlier, do consider whether or not you're happy to give the same level of warranties. What is the importer asking for the exporter to warrant with regards to compliance, and is that appropriate? Do you want to apportion some of the risk on the importer to say that they have notified you of the relevant rules for that jurisdiction before import takes place, for example? And also, which party is responsible for duties and tariffs? Despite this being a duty tariff quota-free trade deal, as I've explained, if goods are not deemed to be originating, they will still apply, and the EU and the UK may impose certain sanctions on each other, which does mean that duties and tariffs become a reality. So you might want to consider who is responsible for those. Enforcement is an issue which my colleague Suzanne will explore in a greater detail shortly, but just briefly to say that in light of the UK's exit from the Legano Convention, judgments against EU countries are no longer as easily enforceable as they used to be. So if you have regular dealings with EU companies, you might want to consider an alternative form of dispute resolution. Suzanne will explore this in more detail. And force majeure, could a party rely on Brexit as being an event which changes the commercial relationship between the parties and entitles one party to terminate the agreement? It might be that there's a concern the other party will do this, or it might be that you want to do this and rely on the clause yourself. Either way, that will come down to the wording of the particular clause. Next slide, please. I've talked mostly about supply and products because this is really the area of the deal which is given the most detail. Supply and services is not really dealt with in quite the same manner. No doubt you will have heard in the media that services has been somewhat overlooked, although not a great surprise, notwithstanding that 80% of the UK economy is service-based. A lot of commentators were not surprised about the relative lack of provisions governing services. The TCA has a few minor wins in there. There's a most favoured nations clause in there, which means that if the EU goes on to negotiate greater terms, trade terms for services with regards with another country or nation, they'll make those terms available to the UK. There's also a national treatment clause, which basically means that UK businesses cannot be treated less favourably than home nation businesses in the EU. There's also a bit in the TCA about business trips that is caveated. It's not a free-flowing right to conduct business trips. There are caveats, which my colleague Patrick might touch on shortly as well. For every advantage, there are significant hurdles. the access to the single market is not what it was. There's no longer automatic access. This does impact on different service sectors in different ways. And as I mentioned right at the start, I do envisage that there are going to be a lot of bolt-on addendums dealing with different service lines. We've already seen that legal services has been given some special recognition in the deal. We're probably expecting that financial services will follow, and there may be some replacement for the passporting, which the financial service sector used to have the benefit of. It's worth mentioning here as well, there's no automatic recognition of qualifications, which does mean that particularly sectors such as, say, engineering are going to, find that there are more obstacles to overcome to supply the services overseas. And also, I'll touch on data in the next slide, but this does tie in with services. Digital trade, tech sector, businesses do have a lot of transfers of personal data, which is stored in the cloud. And, this does involve outsourcing support functions, etc., to EU countries. So there's also a lot of uncertainty on that. If I could have the next slide, please. So with regards to data protection, many commentators were anticipating there might be an adequacy decision as part of the TCA. No adequacy decision has been forthcoming. Instead, we've got this 4 to 6 month grace period whereby it will be business as usual insofar as international data transfers are concerned. But the crucial point here is that the EU at present does not formally recognise the UK as being adequate for the purpose of data transfers. So what does this mean for businesses? Well, overseas data transfers at the end of this 4 to 6 month period. So, it's 4 months automatically extending to 6 months unless either party takes positive action. So we expect around April, June this year. If there's no adequacy decision, then what it essentially means is that if you are receiving personal data from EU countries, let's say hosting providers, support, group companies, etc., without that adequacy decision, that is not a free flow of data, and for compliance purposes, you will need to explore other measures, such as standard contractual clauses, in order to make sure you comply. GDPR will continue to apply in this country, so this is not a radical overhaul of your own compliance procedures. It was formally implemented by the Data Protection Act 2018, and that does remain in place, as does most other European Union legislation, which has already been directly implemented in this country. So I'm not saying you need to do a full-scale overhaul, but this is particularly important if you transfer data back and forth with the EU. The UK government has said it recognises the EU as an adequate region, a safe harbour, but that has not been reciprocated yet. So do bear in mind you will need to take steps to comply if there is no adequacy decision forthcoming. I would recommend you think about that sooner rather than later. Don't wait until 6 months and then find that your business is not compliant. Next slide, please. I'm now just going to hand over to my colleague Patrick, who's just going to touch on the impact of the TCA and Brexit generally for employers and employees.
Yep, thanks, Terry. Hello, everyone. My name's Patrick. As Terry said, I work in our employment department, so I'm mainly going to be talking to you about people issues that might be churned up by Brexit. And I'm going to talk to you about how the trade deal may or may not have impacted things like employment rights. And, if you have existing EU staff or if you send UK staff to the continent, we're going to talk a little bit about what issues might be thrown up there. Now, the first thing I wanted to talk about was employment rights. The main reason being that a lot of the press coverage that immediately came out of the trade deal being struck, there was a fair bit about various politicians calling for reforms to the UK's employment laws. Some from the perspective of make it more employee friendly, some from the perspective of this is an opportunity to streamline red tape for businesses and make us more attractive. So hopefully this slide can kind of cut through a lot of the buzz in the media. The first point there is that existing EU-derived laws aren't going anywhere, that they're not affected by this deal. So there's a large body of employment law that is linked into EU laws. So things like 2P, things like working time rights as well, have a foot in EU original laws. So they will still need to be interpreted with those laws. So we're unlikely to see immediate deviation overnight. The second point is that, well, yes, we're no longer bound by future EU directives, so EU laws, and we're no longer bound by the decisions of the ECJ. But that doesn't mean that we will suddenly see a sort of great sea change in sort of, I guess, our employment law culture in the country. I think mainly because it would be a very hot political topic. We already have a lot of our rights are more generous than the EU kind of default standard as well. And the other reason is that there's actually a non-regression clause within the recent trade deal. So there are some exceptions applying to Northern Ireland specifically because of its kind of unique position within the deal. It will have to still conform with certain EU laws and decisions. But otherwise, for the rest of the UK, the non-regression provision in the trade deal, what that means is that it's an agreement from the UK and the EU not to weaken or reduce the level of employment rights to the point where it would affect trade or investment. So it's almost like a sort of non-competition type clause. It's to prevent, for example, if the UK tried to do away with the limit on the working week, and that would therefore be a great boon to certain employers. So that could create an unbalanced trade relationship and make us more attractive. So there are mechanisms within the deal that would allow the EU to step in and rebalance that and take legal action against the UK if it came to that. So that's the first point, that, despite what commotion you see in the media, we're unlikely to see big fundamental shifts in employment rights. It's one to keep an eye on because, the government may be able to do certain pruning of employment rights, certain minor changes to employment rights that don't impact trade and investment and are therefore fine for them to put through. So it's one to keep your eye on as an employer. Can I have the next slide, please? So I'm going to talk to you about the immigration picture, and I'm going to split it up into EU employees in the UK, and then we're going to kind of move on to the more UK employees moving to the EU side of it. And the first point is that the trade deal hasn't changed a huge amount when it comes to immigration. The reason for that is that the existing position for UK nationals working in the EU and their EU counterparts doing the opposite is that that's going to remain roughly the same as it was before, because that was already agreed in the withdrawal agreement and other points of domestic legislation. So the trade deal didn't have a huge amount to say on the mobility of people. But I'm going to give you that background anyway, because I think it's very useful to know. So from the 1st of January onwards, there's a new UK immigration system in place. Freedom of movement has finished. And that immigration system, it applies to EU and non-EU immigrants equally. And the point of it is that it places more of an emphasis upon skills, qualifications, and work demands as well. So areas where the UK is actively looking to bring in talent. And it perhaps puts more hurdles in the place of lower skilled, lower paid immigration routes. I've jotted down some of the sort of 3 takeaways, I suppose, of that scheme, that if you're going to be hiring foreign workers from now, you're probably going to have to get yourself a sponsorship license. That's going to apply. So you as the company will have your own tests and hurdles to get over. I've highlighted the skilled worker route because for permanent hires, that's probably going to be the most common one. There are many other different types of visa you can apply for, but the skilled worker route involves establishing that the role is of a sufficient complexity to earn the necessary level of points to get the green light from the government, basically. And then just a final point for larger companies, so intercompany transfers, if you are part of a wider European group, there are special routes available to move members of staff between the group structure, and they can be a bit more accessible and a bit more flexible for you. And then just a final point on this slide about the settlement scheme, which shouldn't be forgotten. So although the transition period ended on the 31st of December, there is still the opportunity for certain EU nationals to get a much easier route to the right to work. So if you were a resident in the UK by the end of last year, you still have until the end of June this year to go to the government website and apply for the EU settlement scheme. And it's a far simpler, far easier form of getting the right to work. And I'll come on to this at the end, but I think as the employer, if you haven't done so already, it's prudent to check in with any EU staff you have to see where they're up to with their right to work. Can I have the next slide, please? So I'm going to talk about the reverse situation, I suppose. So if you have UK staff that are permanently heading to the EU to work at an overseas operation, or maybe they're not going there permanently, but they're going there for a short-term project or visit. So the situation is much the same as on the previous slide, but a sort of mirror image for different EU countries. There are similar rules that apply for settled status and the EU settlement scheme. So if you are a resident in an EU country by the end of last year, member states all have a like scheme that you can apply under. They will at least give you until the end of June. Some give you a bit longer until the end of the year to put your actual physical application in. And yes, they're worth looking into, if you're in more of a permanent situation or one of your staff wants to gain residency rights. As for from people moving there or traveling there from the 1st of January onwards, it's obviously a very different picture. The flexibility and ease of access of freedom of movement is gone. And what you're actually going to have to, even if you're going there for a short visit, I think you are going to have to do your research and your planning before you go out and start traveling there. So one thing that the trade deal does do, it doesn't change those kind of big points around immigration systems and the settlement scheme, but it does offer some clarifications for temporary business activities. And it highlights 5 categories where the UK and the EU have broadly agreed certain limits and certain sort of caps on what can and can't be done. So those categories are for contractual service providers, independent professionals, intercorporate transferees, business visitors that are looking to set up a company, and short-term business visits. So for those 5 categories, they've sort of put together a sort of package of clarifications and commitments in the deal that are worth looking at. Depending on which one you fall into, I think they could be used quite heavily. And generally speaking, these types of short visits involve fewer work authorizations and a bit more flexibility. A lot of them will still need visas. For you to actually do substantial work, you're probably going to need a visa. But for example, if you are just going for a short-term business visit, that is generally speaking, meeting a client, going to some form of conference or exhibition, but not actively providing a service, you may not need a visa. But it's important not to be complacent because each country has a different political leaning, has a different kind of culture, and you'll find that whilst one country can be quite flexible and open to visits, another one there'll be far less that you can do whilst on your visit. So it's really a case of being careful, doing your planning and doing your research. I'll just touch on 2 points. If I could have the next slide, please. So I'll just touch on one final point on professional qualifications that isn't jotted down here, but if you're in the type of profession that involves a qualification or some sort of certification, previously there would have been EU agreements that, you can apply that to another member state. You may now need to have that qualification, whatever it might be, recognised in whatever member state you're trying to go to do work to. And each member state could have its own individual rules on what qualifications are accepted and what qualifications aren't. Now, we don't have a lot of clarity on that. That's going to impact a lot of different businesses, but the trade deal does envisage a mechanism that will allow the EU and the UK to agree passes for certain types of qualifications. So Terry mentioned legal services, which have already been given an agreement that, that they're authorised and qualified to provide their services abroad. So it's one to keep an eye on that also could affect you. And then the final slide here, I just wanted to give, I guess, a few takeaway points for HR really, and you know, employers. You know, what are things to look out for? I guess if immigration is ever going to not affect you, in which case, lucky you, or it is, and it could actually be a bit of a minefield that you're going to have to get your head around. So it's a case of doing your planning and taking advice where necessary. Communicating with impacted staff. So that might be existing staff, and you just want to gently check, you know, what their immigration status is, or it might be a new hire. You know, you've got your right to work checks to do. So you can make gentle inquiries to find out where they're up to, but you've got to be careful in doing so, not to hold that against them and discriminate against them. Keep on top of right to work checks. So the EU countries, you know, there's not a special kind of, we're not part of the same political union anymore. So you'll have to know what documents you can and can't accept, and on what dates EU passports are no longer going to be valid as a right to work check. You know, if you mess up your right to work check, there can be liabilities for you, the employer, there. And the final 2 points are just about getting your HR documents double checked. So, you know, if someone doesn't have the right to work, that can be a fair reason under law to end the employment. But it's also really helpful to have things in your offer letters and to have things in your contracts of employment that give you warranties, that give you caveats, you know, if they don't have that right to work. So there are a few things there you can do and sort of take into account moving forward. So that's a whistle-stop tour, really, of people issues. Obviously, you could talk for hours on each one of those, I think. But if anyone has any questions for me, I would be happy to answer those at the end. In the meantime, I'll hand you over to Suzanne, who is going to talk to you about jurisdictional issues.
Thank you, Patrick. Good morning, everybody. My name is Suzanne Carr, and I'm a Senior Associate in the Dispute Resolution team. I'm going to consider the impact of Brexit on some aspects of civil justice. If I can have the next slide, please. There are 4 key areas to consider, which I've shown on the slide, and they are applicable law, jurisdiction, service of proceedings in the EU, and enforcement of judgments in the EU. And then I'll move on to consider some practical steps which companies can take to try and alleviate the issues which have been created by this new framework. Next slide, please. So before we move on to consider the new framework, I just want to look briefly at the framework for civil justice, which applied up to the end of December last year. So when a cross-border claim was issued in the English courts, the permission of the court to serve proceedings outside of the jurisdiction was not required in the majority of cases. And that meant that service of proceedings in other EU member states was relatively straightforward. If a contract contained a choice of law and choice of jurisdiction clause, then those choices would be recognised and upheld by other EU member states. And again, that gave certainty to English litigants with cross-border claims. When it came to enforcement of judgments, English judgments would be automatically recognised under the rules and enforced by other member states. So there was a streamlined process for enforcement of judgments, which meant that process wasn't too costly. If I can have the next slide, please. So we now have a post-Brexit framework, which looks quite different to what we had before. Unfortunately, the Trade and Cooperation Agreement, which Terry talked about earlier, contain no provision for civil justice. So effectively, that places us in a no-deal situation as far as jurisdiction and enforcement of judgments is concerned. But there is an important distinction, and that is between cases which were issued prior to Brexit and those issued afterwards. So why is that? The answer is very simple. Claims issued before the 31st of December are largely unimpacted by the new framework because they remain subject to the rules which applied before Brexit. So importantly, any cases which are ongoing and where judgment is subsequently obtained, that judgment will be enforceable in the same way as it was before Brexit. However, for any claims issued after the 31st of December last year, those claims are going to be subject to the new framework and the new rules. And I'll come on to consider what practical impact that is likely to have. Next slide, please. The first issue to consider is the applicable law. And by applicable law, what I mean is it's the law which will govern the contract. So it will be the law which will be applied to determine the dispute. The post-Brexit framework creates no change here. So parties to a dispute will see no change when it comes to determining which law will apply to determine the dispute. Member states will continue to respect any choice of law clause in a contract. And so parties who have chosen English law to govern their contract will continue to see that choice of law upheld. Next slide, please. Moving on to jurisdiction. What do we mean by that? Well, by that we mean which court will be the appropriate court to hear the dispute. And that can sometimes be different to the law which will govern the contract. The rules which applied before Brexit were primarily the Brussels Recast Regulation and the Legano Convention, but both of those rules have now ceased to apply. It's important to note, as mentioned earlier, that any proceedings issued prior to Brexit will be unaffected by this change. So for any claims issued from the 1st of January this year, those claims are no longer going to have the benefit of the rules in place prior to Brexit. But what does that actually mean for claimants with cross-border claims? Well, before Brexit, other EU member states would be required to uphold the choice of jurisdiction, but this no longer applies. And this could result in courts of other EU member states either not recognising or upholding choice of jurisdiction clauses. And that's going to create uncertainty for people bringing claims, and it creates risk for litigants with cross-border disputes. Next slide, please. The good news is that the UK has already taken some steps to address this problem. First and foremost, the UK has acceded to the Hague Convention on the choice of court agreements. The Hague Convention is a convention which the UK was a party to via its EU membership prior to Brexit. And it now continues to be a party to that convention in its own right. The contracting states are the UK, the EU, Singapore, Mexico, and Montenegro. So what the Hague Convention does is it requires any contracting state to recognise and uphold the court which the parties have specified in an exclusive jurisdiction clause. So where you have a contract and that contract has an exclusive jurisdiction clause, you will have certainty that that choice of jurisdiction will be upheld in any cross-border claim. However, the Hague Convention is limited in its application, and it only applies to contracts where there is an exclusive jurisdiction clause. I'm not going to examine today what exactly that means because it's beyond the scope of the time that I have today. But if anyone has any questions about particular clauses that I may have, I'd be happy to answer those afterwards or after this webinar. The next slide, please. So some further protection is possibly on its way. The UK has also applied to join the Legano Convention in its own right. Now, like the Hague Convention, this was a convention which the UK was a party to by virtue of its EU membership. But now the UK is no longer a member of the EU, the membership of the Legano Convention has ceased. The Legano Convention also addresses issues on jurisdiction and enforcement of judgments, but prior to Brexit, it wasn't as important as the other rules took precedence. But now those other rules no longer apply. Accession to the Legano Convention is something which would be very desirable indeed, as it would address many of the other issues on jurisdiction and enforcement. Well, why is that? If the UK is given permission to join this convention, it means that all judgments of the English courts will be recognised in the EU, and not just those judgments where there was an exclusive jurisdiction clause in the contract. And that's going to give certainty and ease of enforcement of judgments. So the UK applied to join the convention on the 8th of April last year, and it requires the unanimous consent of all contracting states for us to be able to join. We expect consent to be given by the 14th of April this year, if it's going to be given, and that's the expected deadline. And whilst Norway, Iceland and Switzerland have so far supported the UK's application, the EU's position remains uncertain, and there's certainly no guarantee at the moment that the EU will give its consent. And even if it does, it's expected to be at least a year and a half from now before the UK will accede to that convention in any event. If consent isn't given, then English litigants who've got cross-border claims are only going to have protection on enforcement of judgments where they have an exclusive jurisdiction clause in their contract. Next slide, please. There is also some uncertainty as to whether an exclusive jurisdiction clause, which was entered into between the 1st of October 2015 and the 31st of December 2020, will have the protection of the Hague Convention. That just simply remains unclear at the moment. If a claim does arise and a party wishes to rely on an exclusive jurisdiction clause, which has been entered into between those dates, then advice should be sought as soon as possible. For contracts which don't contain an exclusive jurisdiction clause, then the Hague Convention won't apply, and there's going to be no rules for allocating jurisdiction when a claim is issued. In that situation, it will be the English common law rules which will apply. There is the risk of the English courts rejecting jurisdiction in some cases, although that discretion is generally exercised very infrequently. And there is also the risk of what we call parallel proceedings. And that means the possibility of two sets of proceedings being issued in different courts, but on the same dispute. So just to summarise, for parties who don't have an exclusive jurisdiction clause in their contract, then there's going to be very little protection for them under the new framework. The next slide, please. Moving on to enforcement of judgments. I said earlier that before Brexit, enforcement was a streamlined procedure, and that was due to the automatic recognition and enforcement of judgments between member states. But we now have a post-Brexit framework, which unfortunately looks very different. We have no mutual recognition of judgments by member states, and that's going to result in a less straightforward process for enforcement. We do have the protection of the Hague Convention in limited cases, but only where there's an exclusive jurisdiction clause. It is possible that some old bilateral treaties between the UK and other member states may offer some protection, but again, that's beyond the scope of today's webinar, and it would need to be considered on a country-by-country basis. So if you don't have an exclusive jurisdiction clause in your contract, then any enforcement of a judgment is going to be under the rules of the law of the country where that judgment is being enforced. That's definitely going to present procedural hurdles. It's going to be more time consuming, and that's going to add to the cost. And it's going to be the case that the local law advice is going to need to be obtained from the country where the judgment is being enforced. Next slide, please. And finally, on the issue of service of proceedings in other jurisdictions, currently the permission of the English court is going to be required in the majority of cases where proceedings need to be served outside of the jurisdiction. But even if permission isn't required, the process is going to be less efficient than before and more costly. There is some good news, and that is that it's just been announced that a new rule will come into force on the 6th of April this year, and that means that the permission of the court from that date onwards won't be required to serve the claim form in cross-border civil and commercial cases. So that's very welcome news. Next slide, please. Just to summarise on some points. So Brexit, it's not going to affect the applicable law to a dispute. And importantly, English jurisdiction has always been an attractive option for many parties, with English jurisdiction being specified in contracts. And that is unlikely to change. English jurisdiction is going to remain an attractive option, and the changes in the framework are only going to affect cases with a European dimension. Many of you may have been involved in mediation procedures before, and the good news on mediation is that that will remain unaffected, as will the enforcement of arbitration decisions. So for those of you who have arbitration clauses in your contracts, then there's going to be no change to the procedure or the enforcement of an arbitral award. However, Brexit is going to create more uncertainty, as I've discussed earlier, particularly for people who don't have written contracts, or for people with written contracts where they do not contain an exclusive jurisdiction clause. So for the time being, we've got a situation where enforcement of judgments is going to be more complicated and more costly, but hopefully the landscape and these issues will be addressed moving forward by the accession to the Legano Convention. Next slide, please. So just want to touch on some practical steps which companies can take to try and address these issues. As Terry alluded to earlier, it's really important when you're entering into a new contract to consider the issues on civil justice in the event that a dispute might arise. And that's going to involve looking at issues of jurisdiction and enforcement, and also deciding on a suitable dispute resolution clause. And certainly the choice of an arbitration clause might be more important than ever. Do consider, if you have contracts which date back to before Brexit, consider whether they have an exclusive jurisdiction clause in them. And if they do, then you may wish to consider re-agreeing those clauses, and that will give you certainty that a clause will be recognised and upheld under the Hague Convention in the event of a dispute. And finally, if a dispute does arise, then do consider the litigation issues early. It's important to take advice and to formulate a litigation strategy. And that may or may not involve local law advice being taken from a lawyer in another jurisdiction if it appears as though jurisdiction may not be with the English court. So that brings me to the end of my section on civil justice. Thank you for listening. I will hand you back to Terry, who's going to introduce our question and answer session. Thank you.
Thank you very much indeed, Suzanne. That leads us nicely to some questions. I'm conscious we've got about 10 minutes left. I can see we've had 3 questions submitted, so hopefully we will be able to answer all 3 of those briefly. I can see we've had 1 question on data protection, and that is the UK likely to receive an adequacy decision? The adequacy decision is very much in the balance at the moment, I would say. Historically, it's taken the European Union several years to give adequacy decisions to other third countries. You could argue that the UK is in a stronger starting position because we do have GDPR implemented, so there's a more established data protection framework already in place, which gives us a head start, I would say. However, I wouldn't take it for granted. I would say that if you are a business which does trade in data or transfers data overseas, do look at what you can do to mitigate the potential that there will not be an adequacy decision forthcoming. There are things you can do. It doesn't have to be really complicated, but it is an area which you will find that it's going to come around soon, April, June this year. If there's no adequacy decision, you will need to be compliant. So save that last minute rush and address those points now if you can, would be my advice. Just looking at the other questions I've had, there's one here. Why might an exclusive jurisdiction clause agreed before 31st of December 2020 not be upheld? Suzanne, I think that might be one for yourself.
Yes, thanks. So yeah, the reason why an exclusive jurisdiction clause entered into between those dates might not be upheld, and that is because during those dates, that was when the UK, although it was a party to the Hague Convention during those dates, was party to it by virtue of its EU membership. And there's been commentary to suggest that simply won't be enforced because it applied when the UK was a party by virtue of its EU membership, and that it's only going to be now that the UK is a party in its own right that those clauses would be upheld. But again, the commentary, there's commentary both ways, and it's simply uncertain at the moment how that is going to pan out.
Thanks, Suzanne. And a final question is, we send staff to the EU for short periods of time to help set up and attend events and exhibitions. Can we still do this? Patrick, probably one for yourself.
Yeah, it's a tricky question to give a kind of single, simple answer to. It'll all depend on what your staff are doing. You know, if this is, you could have a mixture of people here. I don't know if people are going along to attend meetings or purely as an attendee at whatever this exhibition is. That may well fall under a business visit, which you won't need a visa for. So that could be quite simple to do. I don't know if you have people going along to actually set up the event, maybe if they're engineers or if they're speakers, it's likely that they're going to be doing a more substantial form of work, and you'll have to look into options for visas, work permits, or other documentation. You know, generally speaking, if you're it's those 5 categories that I outlined for temporary activities. You know, unless it's a simple business visit where you're not really doing any work, you're going to have to look into visa options, I think. So yeah, it'd be one to get specific advice on.
Great, thanks, Patrick. Well, that's all the talks and the questions we've had submitted. Do feel free to get in touch with us if you have any more questions. We would like to thank you all for joining us today. I hope you found it useful. As I mentioned earlier, we will be sending this video to all of you if you would like to run through any particular areas again, and you will receive our direct contact details if you want to get in touch with myself on corporate commercial issues, Patrick is employment, and Suzanne as your dispute resolution points. Thanks again for joining. We look forward to seeing you all again soon. Thank you.